gratified that you're here tonight. My first question is, what would you specifically do to prevent abortion on demand and defend traditional marriage?
I just released a fairly lengthy paper, which you can find at newt.org, which takes up item 9 in the proposed 21st century contract and outlines the framework for bringing balance back to the judiciary. Most of our major crises in our culture are driven by radical judges who violate the American Constitution, violate American history, and are doing things that are fundamentally destructive. And for 40 years, conservatives have said, well, I will appoint better judges. After the 2002 Ninth Circuit Court decision that one nation under God and the Pledge of Allegiance was unconstitutional, I got really intrigued. I wrote a book called Rediscovering God in America, and Clifton and I made a movie about it. We then wrote a series of other books, every one of which has chapters on the judiciary. I taught a short course at the University of Georgia Law School, and the paper we just released represents 9 years of thinking about this. The courts were third. Read the Constitution. First comes the legislative branch, which is supposed to be closest to people. Second comes the executive branch, to execute the law passed by the legislative branch. Third, and least important of the three, is the judiciary. The Federalist Papers, Alexander Hamilton says, the judiciary will never pick a fight with the two elected branches because it would inevitably lose it. The Warren Court in 1958 asserts outrageously that the Supreme Court is supreme over the other two branches. Now, it's always been a Supreme Court within the judicial branch. But we were told that Montesquieu's theory of balance meant each of the three branches balanced the other two. Jefferson, when asked about judicial supremacy, said, that is an absurdity, it would be an oligarchy. Lincoln, in his first inaugural, says of the Dred Scott decision by the Supreme Court, and you could argue the Supreme Court's bad decision led directly to the Civil War. And because they said slavery existed everywhere in the country and you couldn't do anything about it. And Lincoln says in his first inaugural, to believe that 9 people could dictate to the entire nation the meaning of the Constitution would be the end of our liberties. Now, there are 4 practical consequences of this. Consequence number 1 is presidents on occasion ignore the court. Jackson thought the United States Bank was unconstitutional. He was told the Supreme Court thought it was constitutional. He said, that's fine. In the judicial branch, they can believe that. In the executive branch, I believe this. We both swear to uphold the Constitution. We're co-equals in interpreting it. And he promptly ignored them. And that's doable. Franklin Delano Roosevelt, upon capturing 14 German saboteurs, explained they would be tried and they would be executed. And he would not accept a writ of habeas corpus from the Supreme Court, and he sent his Attorney General over to say, don't issue it. I'm Commander-in-Chief, we're in the middle of a war. And they didn't. As President, I would say that I would instruct the national security apparatus to ignore the 3 most recent Supreme Court decisions on terrorism, and I would say those are null and void and have no binding effect on the United States. And as Commander-in-Chief, I will not tolerate a federal judge risking the safety of the United States with some misguided interpretation. The second thing you can do is the Congress can clearly use its power to define rights of appeal. The Congress could have said, for example, and if we'd been clever, we probably would have written into the Defense of Marriage Act that it was not appealable. This has been done before. It was done by Jefferson in the Judicial Reform Act of 1802. The third option that you have, and one which Robbie George at Princeton has been studying and which I'm intrigued with, is to take the 14th Amendment, which says the Congress shall define personhood, and pass a law which says personhood in the United States is defined as beginning at conception and goes straight at the court. The last thing you can do is a bit stronger. In 1802, Jefferson, and I remind folks, Jefferson's Secretary of State was James Madison, so you have to assume Jefferson and Madison had some knowledge of the Constitution. In 1802, they passed the Judicial Reform Act of 1802, which abolishes 18 out of 35 federal judges. Over half of all the federal judges they're not impeached, they're abolished. Court's gone, no salary, go home, it's over. Now, I am not as bold as Jefferson. I would recommend, I mean this very seriously, Judge Beery in San Antonio on June 1st issued a decree that not only could students not pray at their graduation, they couldn't use the word benediction, they couldn't use the word invocation, they couldn't use the word God, they couldn't use the word prayer, they couldn't ask the audience to stand, and if they violated his order, he would arrest and imprison the superintendent. Judge Beery's court should be abolished now. We do not have to tolerate radical anti-American judges rewriting the American Constitution and pretending that we are helpless. And candidly, once we have abolished this court, we should serve notice to the Ninth Circuit that they are on sufferance, and if they decide to continue being radical, they will become unemployed.